Hi, everyone, and good evening. We are so excited to be back for another webinar within our Love and Legacy series this month. We've covered a variety of topics, and tonight we are proceeding forward and we're discussing blended families. Definitely something that a lot of families in this generation and day and age are dealing with. And we don't always talk about how to actually protect them. So we're excited to be here tonight. I am standing in for our managing partner, Ms. Eleanor Curry. My name is Marina. I am one of the associate attorneys here at the office, but nonetheless excited to be here with you all this evening. I'll give a couple minutes for others to join in, and then we'll go ahead and hop right into tonight's topic. To be mindful of your time and make sure you get the valuable information that we're here to give. All right. Well, here's a little bit about the Curry Law Firm. Outside of estate planning, we support business owners and entrepreneurs, real estate investors, service professionals, and then, of course, we help families that are building generational wealth. Our focus is really trust and estate planning, probate navigation, if you do end up having to deal with probate, business structuring and strategy. So that's anything from the formation of the business all the way till if you have to send a demand letter to someone for a breach contract or failed payment, or even need litigation representation for a matter going on in your business. And then we also do real estate support as well. So maybe there was some sort of fraudulent deed. Maybe somebody misrepresented the property that you were purchasing. We handle a lot of real estate matters as well. So, a little bit about our managing partner, Miss Eleanor Curry. She was originally supposed to be here to present tonight, but she had an emergency that she had to attend to. So, that is why it says about me. But nonetheless, I do want to tell you a little bit about Eleanor because she is the head of our estate planning division here in the firm. And so, if you did decide to work with us or you did decide to book a call just to kind of explore your options and figure out what the best route or avenue may be for protecting your family and your specific legacy, your call would be with Eleanor. And so it's definitely valuable information for you to know a little bit about her. She's a graduate of Florida A&M University, a proud graduate where she received her bachelor's degree and her MBA. She attended South Texas College of Law here in Houston, Texas. She's a second generation business owner, and she's someone who's lived the challenges of succession planning personally and professionally. So she understands the many technicalities that can come into it, many different complex details that you may need for your specific matter. And then she's able to really talk to you in a relatable way to help make sure that you understand the information and the options that you have. And I think that that's something that's very special. You know, as attorneys, we sometimes have a good understanding of the law, which we should, but can we necessarily be able to communicate that in a way that just a regular person can understand? And Eleanor is very great at that. And so I think that's what makes her a special attorney and very skilled and capable in the area that she practices in, and makes you feel like your legacy is really being protected, valued, and is important to those of us here at the firm who are working on your estate plan for you. So that's a little bit about Miss Eleanor Curry. There's more on our website at www.theclfirm.com. You can read her full bio there. And so, goals for tonight and why this topic matters is that blended families are absolutely beautiful, right? And I talked a little bit about that before, is that it's very common to have a blended family. I come from a blended family. My dad had six sons when he met my mother, and she had one daughter when they met. And then together they had two more children. So, blended families are beautiful, but they're legally complex. And so you may be in situations like myself where, because my dad had been in my older sister's life so long, he considers that one of his children, but legally speaking, That's not his child. And so, what does that look like when you're trying to make estate plans, right? Do you include that stepchild? Is that stepchild automatically included due to how long the marriage has been going on? It just really varies on what it is that you want. And so, tonight we're going to talk about some of those details that make things a little complex when it comes to blended families and how to make the best decisions for what it is that you want to do. Um, Without proper planning, children can be unintentionally disinherited, right? Surviving spouses can be left financially vulnerable. There can be conflict between step parents and stepchildren, and probate disputes become likely. And you may think like, okay, well, my spouse and my children that I had before my spouse get along great. That is phenomenal. But when we're talking about someone who is in a period of grieving, their normal day to day emotions are not always present, right? And you may meet a different side of somebody when they're going through the process of grieving, as well as trying to figure out what navigating this process of distributing an estate looks like. And so, the more that you can put in detail, the more that you can make clear and have in writing, the easier time people can have with kind of grasping on to the grief that they're dealing with and handling everyday life, as well as trying to navigate this distribution of assets process and procedure. So, what exactly is a blended family? Well, you have second or later marriages. Their children from prior relationships are present when you enter into that second marriage or maybe a marriage after that. And that's when you have that ours, right? There's a movie called Yours, Mine, and Ours. And so that's referring to children from the current marriage. So I gave the example of my dad having sons before he met my mom. My mom had a daughter before he met my dad. And then they had two children while they were together. So you have yours, you have mine, and then you have ours. And so that can include stepchildren, and it can also include ex-spouses with ongoing financial ties. Maybe there is still child support or back child support that's owed to a specific ex-spouse, or some sort of debt from a divorce from a prior marriage that you're still trying to pay off towards the ex-spouse. And so those may become community property, right? Texas is a community property state. And so debts of one spouse become community property, right? So it's the debt of the community itself. And here's a fun fact is that today, over 40% of marriages involve at least one spouse who has been married before. So that's a big number, right? It's definitely a good sign for finding a spouse or someone else, someone who's out there if you are still looking. But it's beautiful to know that there are second chances for love and there are second chances for families to be able to continue together and flourish. All right. So the core conflict that can arise is that blended family planning always balances three goals: to protect the spouse, provide for your children, and prevent future conflict. And if you don't plan intentionally, then state law will decide for you. And so ultimately, the whole goal here is to be able to create a plan that can include your spouse, include your children, and to prevent the conflict that can arise when there isn't clarity in what exactly the plan is and what it is that should be followed out. So, what happens without an estate plan? So, under Texas Estates Code, if you die without a will, that is when the intestacy laws take place. When you die without a will, when there's no specific plan in place for the courts to follow. So, that means that your spouse does not automatically inherit everything. Your half of community property may pass to your children who you had prior to the marriage, and then stepchildren could inherit nothing unless you adopted them, and your estate will likely go through probate. Many families are actually shocked when they hear this. So we actually have a client, and she's a continued client of ours, and she reached out and she was like, "Hey, do I actually need to have an estate plan?" They have a blended family, and she was like, "My husband and I are both of our names are on the home, but do I need to still have anything in writing?" And we told her absolutely. She was shocked to find out that even though she's married, even though that both her and her husband's names are listed on the deed for their home, that her estate would still go through probate if she was to die without any sort of formal estate plan, which includes typically a trust, a pour over will to cover anything that was accidentally left out of the trust, medical directives, medical power of attorney, and durable power of attorney, such as to handle financial matters and ongoing matters for the individual. So, yes, people are absolutely surprised when they find out that although they're married, if they do not have an estate plan, then their estate will still go through probate. They would think that it would just go to the spouse, and that's not the case at hand. And the other thing is that you want to make sure that the children who you want to inherit from you are absolutely in the position to be able to inherit from you, and you get that in writing. So let's talk about a real world scenario. So let's use Mark. Mark remarries. He has two children from his first marriage. He dies without a trust. What is the outcome under Texas law? So his wife keeps her half of community property. And when we say community property, it's any sort of property that the deceased spouse came into ownership of during the course of the marriage. So homes, vehicles, anything of that nature. If it was brought into their ownership during the course of the marriage, and there's no sort of postnup or prenuptial agreement that states that it's to remain separate property, it becomes community property. And so when you talk about a home or you talk about a car, you can't just split it in half, right? You can't take a knife and just divvy it on up between the living spouse and the children that you had before marriage. So sometimes that looks like having to sell off certain assets, and each side gets to keep their half. Or there's some sort of agreement that can go into place where their surviving spouse can pay out the value of half of whatever that community property is to the children that were had before the marriage. And so when it says that his half passes to his children, that's referring to any children that Mark had before he became married to the current spouse. And so now the wife co-owns assets with their stepchildren. And that may be something that they're okay with. You know, maybe the stepchildren are very close with the current wife and they say, okay, you know what? Well, when Mary passes away, then we'll go ahead and sell, and we'll be able to distribute profits from the house or from the vehicles, but we want her to still be able to continue her normal day-to-day life, live in the same home, be able to drive the same car that she's used to driving. It's completely up to how they decide to do that, but legally speaking, the wife owns half and the children before marriage own half. Any children that are considered ours, meaning they were born between the spouse that has passed away and the surviving spouse, they don't inherit directly now. They're going to inherit when the surviving spouse passes away. So common blended family estate planning mistakes. Number one, leaving everything outright to a new spouse. That can leave out the children that you had before you entered into the marriage, because they wouldn't be able to inherit anything unless the surviving spouse names them specifically in an estate plan that they create to be able to inherit those assets from the surviving spouse when they pass away. Assuming that my spouse will do the right thing. Like we said before, you and your stepchildren could have the best relationship, or your spouse and your stepchildren could have the best relationship. However, when someone has passed away and that person is dealing with the emotions and the load that come with grieving, and then they're having to worry about this, everyone is not thinking the same way that they think now. They're not interacting with each other the same way that they interact now. Maybe the spouse that passed away was always the peacemaker. They no longer have the peacemaker or the umpire there to be able to decide what is right and what's going to happen moving forward. So simply assuming that my spouse will do the right thing. I'm not saying that your spouse is evil and is gonna, turn into the stepmother from Cinderella, but you never know what someone's emotions are going to look like when they're going through the grieving process and how that looks when they're trying to distribute the assets. Relying only on beneficiary designations. So maybe you have a life insurance plan and you've outlined certain beneficiaries there, and you're like, you know what, that's enough. There are so many other decisions that have to be made on your behalf when you become deceased that you need to make sure that you have the proper documentation in place. Simply having designations of who's going to benefit from something like a life insurance policy or from other retirement account, or from a bank account, that's one thing. But people are going to need to make day-to-day decisions on your behalf. If just calling the mortgage company, they could need, some sort of proof of power of attorney just to be able to speak to whoever is the surviving individual, whether it's a child or whether it's a spouse. And so you need to make sure that you have these items in writing just to decrease the amount of conflict and the amount of stress that you're leaving for your loved ones. Um, Failing to update old wills. Maybe you were married previously and you never took out your ex-spouse. Like, that happens more than you think it does. And so then your family has to go through the probate process to be able to prove to the court that that was unintentional, that you never went back and updated anything. Maybe the old will was created before you had these two new kids with your new spouse. And so they don't even name the new children at all. And then naming stepchildren without clarity, right? So you just have a stepchild's name listed, but there's no clarity on what type of assets they should receive, if they should be treated equally as your biological children are treated, or maybe you want your stepchildren to inherit something, but not as much as your biological children. It needs to be made clear. And so these are just common mistakes that blended families make when they're going through the estate planning process. The risk of I'll just leave it to my spouse. And we talked about that a little bit on the previous slide. I'll let my spouse handle it. Maybe your spouse that is a surviving spouse was always good at organizing, always good at distributing, always good at making decisions for the greater good of the family. That does not mean that that is what their mindset will be when they're actually in the position to make those decisions after you've passed away. So ultimately, this is going to be something that occurs when you leave the assets outright to the surviving spouse. This gives them the power to be able to change the beneficiaries, to remarry, to spin down assets, and to be influenced by new relationships, not just relationships that are romantic, but maybe it's friendship, maybe it's a family, and they're talking to someone who has been hurt or who is like, oh, you could use that on whatever. Don't think about those children. The surviving spouse should have put that in their will or their trust if they wanted you to leave something for those children. You just can't leave it in the hands of the surviving spouse. You never know what mindset someone is going to be in when they are going through the grieving process. And I know I've said that a lot, but when we're looking at the clients that are coming in who are going through contested probate matters, and they would have never thought that even a sibling or a step parent would have treated them this way, it isn't something that anybody could plan for. But when you find yourself in this situation, you're trying to fight as hard as you can to be able to inherit what's rightfully yours, and to think about what the spouse who has now deceased or has now passed away would have really wanted. And so good intentions are not legal protection. You really need to have a legal protection and have things in writing. And so that's really important, because if you just leave it all to your spouse, then your children have zero protection, right? The whole point of a trust is to create some guardrails there, create some sort of protection there for the other parties that you love and that you care about. Estate planning goals for blended families. So when we talk about what a strong plan should include, here's some things to really think about. Number one, it should provide income for the surviving spouse, so that the surviving spouse isn't having to change their normal day-to-day life, that they don't have to now find a new place to live or a new vehicle to get them from place to place, because they've had to sell those to be able to give half the profits to the deceased spouse children that they had prior to the marriage. It should protect the children's inheritance. You don't want the surviving spouse to be able to spend all of the assets so that there's nothing less to distribute once that surviving spouse passes away. Control asset distribution. That means that you can control how the assets are distributed. That's when, how, and how much, right? Maybe you didn't want them to be able to receive, the full 1.5 million that you left for each child all at the time of your death. Maybe you want it to be spread out over the span of their lifetime. You can do that. That's called asset control and how it's distributed. And you can do that with a trust. You want to minimize estate taxes if applicable. There are certain tax benefits when the assets are passed or distributed directly to a spouse. There are taxes that you can bypass with that. And ultimately, you want to avoid probate and you want to avoid conflict. Those are the biggest things that people want to avoid. These just having a strong plan that includes these characteristics can make sure that your spouse feels supported, make sure that your children are protected, and make sure that your wishes are honored. And I can't think of anything that more that you would want than to give that peace of mind to your loved ones and feel at peace with the way that things are going to run upon your passing. So let's talk about a revocable living trust. What exactly is a revocable living trust and what does it allow you to do? So a revocable living trust means that it can be revoked at your time of living after you have created it. When we talk about a trust, one of the main benefits is that it can shield your assets from creditors. However, revocable trusts aren't always able to shield your full assets from creditors because technically speaking, you could still be a beneficiary of a revocable trust. When you have an irrevocable trust, meaning that once it's created, you cannot revoke it or you cannot take it back, then that means that you are not a beneficiary of that trust. That is the one that is ultimately shielded from creditors. So I highlight that just in case one of the goals for you and your specific family is to be able to shield assets from creditors. You may want to discuss with the attorney an irrevocable trust and how that could benefit your specific situation. So let's pivot back to revocable living trust. So a revocable living trust allows you to control how your assets are distributed, avoid probate, provide structured inheritance, and add protections for minor children. This is often the foundation for blended family planning. So, having a trust in place. A trust is an elevated estate planning tool above a will. So, a will still has to go through probate. A will doesn't always have things that are outlined for protections for minor children and who should become the guardian if you pass away and there is a minor child. Maybe you're a widow, right? You can be a male or a female widow, and you had children from your prior marriage. And so you pass away, and now this minor child, has zero living parents. It's not automatic that the surviving spouse for this blended family would become the guardian or the caretaker for that minor child. And so having a trust that can address the protections for that minor child is super important. I think that's something we look past when we talk about estate planning and having a trust or a will. We're usually talking about asset distribution and asset protection, but a huge piece of your life are your children. And wanting to make sure that you have a plan in place to address the protections for your minor children is super important. And so I just want to highlight that that's something sometimes that people glaze over when they're thinking about estate planning. But if you do have any minor children, that's even more of a reason to make creating your trust an immediate issue, because tomorrow is not promised and anything could happen. For me, myself, I have two children, and I can't imagine, the stress of family having to figure out what to do. I am from another state. I'm not originally from the state of Texas. And so what happens then? Would, the family from a different state take care of them, and leaving that decision up to family members, not necessarily knowing what my husband or I would want, isn't the type of confusion that I want to leave. We absolutely want things to be clearly outlined so that there is a plan in action for our minor children. The marital trust strategy. So, when it comes to creating a marital trust, there are many different details about your specific life and characteristics about your specific life that can alter what the best strategy to use is going to be. Like, there's no one size fits all when it comes to this. And so there are certain things to consider, and what it is that you want a marital trust to do. So you're going to want something that can allow the surviving spouse to receive income. You're going to want a trust that allows for access to principal under defined standards. So that means that, yes, certain assets can be touched before surviving spouse pass away, but let's set some standards for that. So there's some guardrails up and all the assets are not spent, before this spouse passes away and nothing's left for the children after that. And you want your remaining assets to pass to your children at your spouse's death. So those are things to be able to think about when we are considering a marital trust strategy, and what's going to be best for your specific situation. Once again, we want to make sure that the surviving spouse feels supported, your children are protected, and your wishes are honored. All right, a QTIP trust. This stands for Qualified Terminable Interest Property Trust. When you want to protect children from a prior marriage, this is the type of trust structure that you may want to consider or at least look into. Once again, there's no one size fits all, and there's many different types of techniques and procedures to be able to protect your assets, to be able to protect what your children can benefit from your assets, and make sure that you have a plan in place that speaks to your specific lifestyle. So, a QTIP trust guarantees income to your spouse. It prevents your spouse from redirecting assets after your passing, and it also preserves assets for your children. This is an extremely powerful tool in second marriages when you really want to ensure that the surviving spouse is taken care of and that your children are taken care of too. So I would say to take note of this so that when you do have a consult with an attorney, this is a question where you can ask further information on. And after that attorney listens to the specific details of your finances, of your familial situation, they can let you know if this is a good strategy for you to implement or if there's a more powerful strategy that would better be applicable in your specific situation. Credit shelter and bypass trust. This is another option to have in your tool belt when you are thinking about which route to take to be able to best protect your assets. So it protects estate tax exemption for larger estates. And while many families fall below federal estate tax limits, asset growth can change that. So asset growth is when you have maybe put a certain amount of principal in an account. However, there's been a growth in assets. So maybe you own a piece of property, and the value of the property has severely increased, right? It doesn't mean that you have that cash on hand, but the value of that property that's listed in the trust has severely grown and puts it in another tax protection bracket. And that can also happen with the amount that you have put in any sort of investment accounts. Maybe the principal, right, doesn't qualify for that specific tax benefit. But once you add on the accrued benefit from that, from the financial gain, then that does put you in a different tax bracket. So strategic planning avoids future tax burdens. Ultimately, we want our loved ones to be able to benefit from what it is that we built, what it is that we're growing, and what it is that we want our legacy to live on to be. But we don't want all of that to be overtaken by taxes. And so sometimes you see these articles and it's like, here's what the IRS thought they were going to get from this person's estate. Maybe the estate was valued at $3.5 billion. However, the IRS was not able to capture a single dollar because of the strategic tax planning that this individual took when they created their estate plan. And I think this is a great example of how financial planners and wealth advisors work hand in hand with your attorney. And so it is not uncommon for us as attorneys to hop on a call with your wealth advisor or with your financial planner to be able to discuss what it is that they're telling you for tax and financial purposes, and make sure that we have it appropriately in writing when we are drafting the estate plan itself. So if you know that you have any sort of portfolio that's very high in value, then that's what you want to be able to make sure is set up. That's a phone call between and a good relationship between your attorney and between your financial planner or your wealth advisor to make sure that the legal documents that you have in place to protect your estate include and plan for what it is that you're doing on the financial side with your wealth advisor, with your financial planner. Separate property versus community property. So we briefly touched on this earlier, but under Texas Family Code, community property is any property acquired during the course of the marriage. That's unless there's something in writing stating otherwise, or the law says that, certain gifts that you may have received individually, although you're still married, are going to be considered separate property. And then separate property is anything owned before the marriage, anything you inherited, so like a gift, and anything you were gifted. And so it's really important for families to clearly identify what is community property and what is separate property. Classification matters significantly more than you could even imagine. And commingling those properties or like commingling things that you've inherited with the community itself can blur the lines and create litigation risk. So maybe you received or inherited a house, but now you and your spouse live in the house with a blended family. That can kind of blur the lines on what exactly is still considered to be separate property and what should be considered to be community property. And so that's important to discuss and have clearly in writing. So let's talk about another real world scenario. Lisa inherits $500,000 during her second marriage. She assumes it will go to her children that she had prior to getting married, but she deposits it into a joint account, an account that's owned by both her and her current spouse. At death, questions arise. Was it separate? Was it commingled? Who gets it? This kind of confusion is what creates lawsuits and what puts you in court, having to spend a bunch of money that your family could have just been happy with and inherited with, now on court costs and now on legal fees, right? Because the law says that anything that you've inherited is viewed as separate property. But Lisa, she placed that money into a joint account. So was it her intention that it was to become community funds? Or did she assume truthfully that it would go to her children? And then although it was in the joint account, the surviving spouse would just hand that money over to the children. So when you don't have this in writing, that is when issues occur. That's when people become frustrated and in confusion with one another, and they end up in court. So protecting children from a prior marriage. These strategies include separate children's trusts, lifetime discretionary trusts, staggered distributions. Remember, we talked about you can outline when and how they receive distributions. It doesn't have to all be at once. Asset protection clauses. And this also protects from divorce, from creditors, poor decision making, and remarriage complications. So when you are thinking about protecting your children from a prior marriage, or you're thinking about protecting prior children from your current marriage, these are some strategies that you can implement. You don't have to implement all of them, but maybe you pick and choose what's going to be best for your specific situation. And one of the super cool things about working with the Curry Law Firm is that we're tailoring your estate plan to your specific needs, right? There's no sort of cookie cutter template that we're using. We take the time to get to know your details. We take the time to understand your wishes, and then we draft the estate plan to match what that is. So what about our children? Remember, we had your children, my children, and then the children we had during the course of this marriage, which are ours. So our children add a bit of complexity. Do you divide equally among all the children? You don't want some children to feel left out or feel that the children that were born during the current marriage are getting more than the children that were born before. Do you provide more to children from the prior marriage because you know that the children who are born of the current marriage will then be able to not just receive assets from you passing away now, but also when the surviving spouse passes away. Um, can you equalize this playing field using life insurance? One thing to know is there's no one size fits all solution. You really need to look at what it is that is going to be considered separate property, the value of that separate property, because once again, separate property is split 50% to children that you had before the marriage, 50% to your surviving spouse. The 50% that's going to children you have for before the marriage, they get it immediately. Now, the 50% that is going to the surviving spouse goes to the surviving spouse. And the law says that when the surviving spouse passes away, then the children born during the current marriage can then inherit and can then benefit from those assets. But you can also deal with, things increasing in value during that time. And so now the 50% that the children got from who you had before the prior marriage, their value is not as high as what the children who would inherit after the surviving spouse passes away inherits, or the value of that property could severely decrease. So the 50% that the children from your prior marriage got is not the same value that now the children from your current marriage are going to receive after the surviving spouse passes away. And so that's when you kind of want to think about different tools or different avenues or strategies to put in place when you're trying to equalize the playing field so that there's no sort of conflict between the children, no sort of resentment or feeling like these specific children are against the other set of children or anything like that. I understand that all your children may get along now, or they just have small little sibling rivalry, but it's nothing large. Big picture, bigger scheme, they all love each other, they all get along. We have clients that we're representing them against their siblings. That's the truth of the matter, and it happens every day. So think about long-term protection, and you think about what is best for them, and that's what you're going to put in place. All right, life insurance as an equalizer. So this is one strategy to have in your tool belt when you're trying to equal the playing field. So life insurance can provide immediate liquidity. It can replace inheritance for children. It can equalize estate shares, and it can protect minor children. And we often use insurance strategically in blended family planning. And this is used to balance the fairness because it allows for each to ensure that each person is getting the exact same amount, not reliant on a surviving spouse, not reliant on what the value is worth at different times. It can equal the playing field. All right. And then another thing to kind of highlight, I'll say, when we're talking about life insurance, because life insurance is viewed as a private contract where you list the beneficiary specifically with the life insurance company, and it can be distributed without any sort of court interference once a death certificate has been provided to the life insurance company. Another area are going to be retirement accounts. A lot of times those are private contracts as well. The retirement accounts pass by beneficiary designation, meaning that you've already outlined with the investment firm or the actual bank or whoever it is, the exact individuals that should benefit from those assets upon your passing, and they override your will and trust. Once again, it's a private contract. So the common mistake is naming the new spouse as 100% beneficiary, and that can unintentionally disinherit your children. So coordination is going to be crucial when it comes to that. All right, prenuptial and postnuptial agreements. This is an area that kind of dabbles into estate planning, but also dabbles into family law. And so for prenup and postnuptial agreements, we typically refer you to a family law attorney to be able to draft something that they know will be binding in family court. And that can best protect your assets that way. But we have no problem having conversations with the family law attorney that you decide to go with to draft that, to make sure that your estate plan can reflect the prenuptial and postnuptial agreements and work hand in hand in creating those for you. So these are types of agreements that clarify property classification, what's separate property, what's community property. Once again, in the situation we discussed with the lady named Lisa who inherited 500,000, if she would have had a postnuptial agreement in place to add clarity and specifications that this is intended to go to my children, both the children I had before the marriage and the children that I have had during the course of the marriage, that would have cleared things up and prevented a lawsuit. It can protect the children's inheritance, reduce future disputes, align estate plan with marital expectations. That's why I said we work hand in hand with the family law attorney to make sure that the wishes are thoroughly outlined in the estate plan that we're building. And ultimately, they reduce ambiguity before it becomes conflict. So they're there to provide clarity, not to make you feel that your partner doesn't trust you, your partner has plans to leave you, or anything like that. It's there to provide clarity and prevent lawsuits. Guardianship planning for minor children. So if both spouses have minor children, who becomes the guardian? Is it the biological living parent? Is it the step parent if there is no living biological parent? Is it a grandparent that you may want the minor child to go to instead of the surviving spouse that is the step parent? There are many options to have in place. And failing to designate leaves the decision to the court. And if the child is 12 years or older, then the court can take their opinion into consideration. But once again, that's the child's opinion. They may not necessarily be thinking about all the things that as an adult we're thinking about. So that's their ability to take part in day-to-day activities that are, extracurricular activities, the ability of the surviving spouse or the grandparent to get them to and from those activities. The ability to have them in a school setting. Maybe you have them in private school and you try to think which individual will be able to continue that. There are many thoughts and processes that go in place when you're trying to decide what is best for the child. And you want to have it in writing ultimately so that the court is not making the decision for you. And courts don't know your family dynamics, right? Maybe there's certain things that with a specific child you're thinking about what's important to them and who would be the best person to support that and make sure that that child can feel loved and supported in the way that they need to. Asset protection for the surviving spouse. This is something that is very important to consider because we've seen it where the surviving spouse is now having to figure out a new house to live in, is now having to sell off a lot of the assets that were community property, and they're losing their day-to-day normal. And this can significantly decrease their expected life span. It may not be something that you would think about, but those things that affect someone's mental strength when they're already going through a severely emotional time, someone's financial capability to feel strong enough to just live on their own or feel like they have to rely on others, that can really affect their health, right? And their health can decrease when they feel like they have no control, when they don't feel a reason to continue on, when they don't feel supported. Asset protection plays a part in that for the surviving spouse. So sometimes the goal is to protect the spouse from children pressuring distributions, poor financial decisions made by that individual, creditors being able to attack those assets that they've inherited, and remarriage complications. So once again, trust create guardrails. And that is why we stress having a trust in place. You very rarely hear us talk about us wanting you to have a will. When we do talk about it, we want you to understand the difference between a trust and a will, and how a specific type of will called a pour-over will can be extremely useful in supporting your trust and supporting your wishes. But you'll never hear us just talk about having a will in place on its own. Granted, we do have those clients that maybe just want a will, and there's nothing wrong with that. We are here to meet the client's wishes, but we're always going to educate you on what that process looks like after you pass away. Because a lot of the times the costs for probate far exceed double, triple, even quadruple the amount that you would pay to create a trust. And so sometimes people are like, well, I don't really have that much in assets. I don't really need to create a will. We can look at legal strategies that help individuals that have a small estate. A lot of states have laws that are specifically geared towards small estate distribution. And that means that the value of the estate of the deceased individual is low in number. And typically, the states that do have laws surrounding that have like a set limit. Like if the estate is valued at $75,000 or less in personal assets, then you don't have to go through probate. You can go through the small estate administration process. But we can talk to you about those options. Stepchildren, what rights do they have? In Texas, stepchildren inherit nothing unless they've been legally adopted or unless they've been specifically named in the trust to inherit from their step parent. Many families assume otherwise, right? And so clarity can prevent heartbreak, meaning that you don't want your stepchild to feel like they weren't loved or they weren't valued with you, especially in those instances where you've grown an extremely close relationship with you and they view you, when I say you, the person that may be the deceased spouse first, as their actual parent, more so than their biological parent because of the relationship that they have with you. You don't want them to feel like that was nothing, that they didn't have that close relationship with you. So considering stepchildren inheritance is also very important. Communication strategy. Communication is a tool that can save you so much headache and so much money in relationships itself. And so estate planning for blended families requires honest conversations between spouses and with adult children when appropriate, so that everyone can go in with a clear understanding and clear mind. It is always sad when you see any sort of conflict arising in family members because there was no conversation that was had as to where the surviving family members are just finding out about how assets have been redistributed. Maybe the last time that they heard they were going to receive something and now they're not. And so it's important to have those honest conversations so that people can ask questions and understand what your wishes are instead of feeling like, someone may have convinced you to change your estate plan or anything like that, as to where it's leaving unnecessary conflict between family members. Surprises create lawsuits. That's the one instance that we're talking about. Maybe there's 5 children and you decided to disinherit one child but never even told the child. Now they're feeling like some of their siblings may have tried to persuade the parent to disinherit them. They don't know. And now they're spending money on attorney's fees, court costs, trying to fight to get what they last knew that they were supposed to inherit from their parent. Transparency creates peace, not just for the person that's passing away to know that there won't be any sort of conflict, but peace between the people that are still living and having to coexist with one another and having to live. So communication is such a huge tool. Isn't necessarily like a legal strategy, but it is a tool that can make things so much easier for your loved ones, for yourself, for everyone involved. So here's kind of a checklist and trying to consider, what does your plan cover and what does your plan need to cover that it doesn't already cover? If you check 3 or more, then you need a special blended family planning. That means that you shouldn't have any sort of like basic standard template for your estate plan. And once again, all of ours are custom that we create. So we're creating it with your specific details and with your specific thoughts in place of what's important to you. So if you're in a second marriage, if you have children from a prior relationship, if you have minor children, if you have business ownership percentage, if you have separate property inheritance, if you have any sort of life insurance policies, if you have retirement beneficiaries listed that don't align with what is in your estate plan. So if you can check off 3 or more of these, it's probably beneficial that you give us a call. You don't have to call us. You can call another estate planning attorney or a law firm, but you actually want to talk to someone about putting a strong estate plan in place to ensure that your loved ones are cared for, that your spouse is protected, that your children can inherit what you want them to, and that there's peace of mind and clarity in what is going to happen. The cost of waiting, truthfully, blended family disputes are among the most litigated probate cases. Planning now costs less than the litigation later. And that's why I was saying that even in instances where there isn't, a $3.5 billion estate, we may still recommend the trust because those like preparation and planning to get a trust prepared is less than the actual probate and litigation costs. It is. Blended families require blended solutions. So maybe that's a blend of different types of strategies that we discussed here in your estate plan, and not having just one type of trust and one type of strategy, but having different strategies to come up with a plan that's unique to your details and your characteristics for your estate. Estate planning is not about choosing sides. It's about providing clarity and control in how your assets are distributed and who is going to care for any sort of minor children. One area that we didn't hit on are those adult children that are incapacitated in any way. And it's about protecting everyone equally. So how can we help? We design, customize revocable and irrevocable living trusts, meritable and qualified terminal trusts. And we also look out for the children's inheritance trust, where we can create separate trusts for each specific child. We can talk to you about different asset protection strategies and work hand in hand with your financial planner or your wealth advisor on this, and coordinate beneficiary designations to make sure that the beneficiary designations listed in any sort of retirement plans and insurance plans match what's listed in the estate plan and are thoroughly outlined. Every plan is tailored and not templated. And so I think that's really important for you to understand. Our contact information is listed here. We are currently running a special to the end of the month. It will expire on February 28th, but we're offering 20% off a marital trust, or buy one, get one 30% off. So if you buy a trust and you get a second trust, then it'll be 30% off. Maybe you want to do those separate trusts for each of your children. Maybe you are like, hey, this is really important for my spouse and I right now, but I have a parent that's like in their late 80s or early 90s, and I want to get their estate plan in place too. That could be the second trust. Maybe you want to grab a best friend and you're like, hey, let's go ahead and get these trusts in place now, and you guys can take advantage of the buy one, get one special. So if y'all have any questions, please feel free to call our office line 24 hours a day. Our reception line is open, and we are happy to get you set up with a call with our estate planning team, or other people at our firm who can help create an estate plan that's tailored to your specific needs. We hope you found this information helpful, and we're so happy that you were able to stay and hear the information we shared. We did kind of just briefly highlight a lot of different items to consider. We're happy to dive into deeper detail with you on a phone call and figure out the plan and strategy that'll work best for you. Thank you so much, and we look forward to hearing about how your estate plan has created clarity and control for your family.